All right, peace and blessings, everybody. It's Wednesday, February the 7th, the year 2018, and I talked to Pat Parsons this morning. She sent me a PDF file that was the United States response to Michael Parsons' appeal, and it also has some notes on it from Michael Parsons himself. Before I get to that, my wife just told me that one of the tiers in the Bundy trial has been dismissed with prejudice, which I'm hoping means that a bunch of guys with the Bundys are now free, at least 4 of them. But I'm sure my wife will give a better update later on. She seemed very excited about that. Also, some good news, unrelated to prisoner stuff, is that I drove my 94 Chevy C1500 today after changing out the intake air control valve last night, and it did not stall not even one time today. So I'm very excited about that. I still have to replace my O2 sensor, but that's in the, I ordered that, and we'll replace the O2 sensor when that gets in. But anyway, let's move on. So this, if you go to more up here and you click on Mike, Pat, Sue, it'll take you to this page, and you can see pictures of Pat Parsons, Mike Parsons, and Sue Holland. And you can scroll down and learn about their case, and the letter that I'm going to read today is 10 pages, and it's the United States response to Mike's appeal. And this is it right here. It's the United States of America versus Michael Wayne Parsons. Introduction. The defendant, Michael Wayne Parsons, has filed an interlocutory appeal of an order filing 37 issued by the United States District Court for the District of Nebraska, which denied several of his motions, to include a motion to dismiss, to recuse the assigned magistrate judge, and to stay an order requiring him to submit to testing for tuberculosis while in detention. Parsons is pro se, although standby counsel, the federal public defender for the District of Nebraska, has been appointed. Parsons is named in a 1-count indictment charging him with being a felon in possession of a firearm in violation of 18 U.S.C. 922 G1. Prior to his initial appearance, the government filed a motion to have the court compel Parsons to submit to tuberculosis testing as required by the policies and procedures of the United States Marshal's Office. And then Mike wrote underneath that, no law, a policy by a corporation posing as a government agency. The defendant had previously refused to submit to such testing and, to date, still has not submitted to such testing. In addition to opposing the government's motion, the defendant moved to dismiss all charges, contending he is a Chilchiquoten tribal member and an ambassador of the made-up country of Chilchiquoten. And then Michael writes underneath that, Mike Parsons writes underneath that, aren't all countries made up? Notice he omits reference to the Chilchiquoten nation, and as a consequence is protected by diplomatic immunity as set forth in the Vienna Convention on Diplomatic Relations. He also moved to have the magistrate judge recused on the grounds she was alleged to be biased against him. Both the magistrate judge and the district court ruled against Parsons. The court found there was no evidence he was an ambassador entitled to diplomatic immunity. And then Mike wrote, the court ignored the evidence. He has now filed an interlocutory appeal seeking to have this court dismissed or transfer this matter to an Article 3, Section 2 Constitutional Common Law Court of original jurisdiction in all cases affecting ambassadors. Petition by special appearance, page 1. Section 1, Facts and Procedural History. On April the 19th, 2017, the grand jury in the District of Nebraska returned a 1-count indictment against Michael Wayne Parsons. The indictment charges Parsons with being a felon in possession of a firearm in violation of 18 U.S.C. 922 G1 DCD1. At the time of his indictment, Parsons was in custody of the state authorities. At the time of his indictment, Parsons was in the custody of state authorities in Tennessee. On September the 12th, 2017, a writ of habeas corpus ad prosequendum was issued by the court directing that Parsons be taken into custody and brought to the District of Nebraska to answer charges, DCD-8. On December the 5th, 2015, the government filed a motion to compel DCD-13, seeking, and then Michael put a star underneath that and wrote false. It was filed on 12/18/2017, to have Parsons ordered to submit to tuberculosis testing. as required by the policies and procedures of the United States Marshal's Office. On December the 18th, 2017, Parsons made his initial appearance, refused to acknowledge his identity, and complained he was entitled to diplomatic immunity. Not complained, claimed he was entitled to diplomatic immunity. False. I clarified who I am and that I am not all capital letter entity. I can't read that next. Oh, I'm not all capital letter entity MWP, Michael Wayne Parsons. DCD 15, the court appointed the federal public defender to represent Parsons. DCD 19, however, at the request of the defendant, the federal public defenders, and then Michael wrote underneath that, false, the public defender advised he was appointed prior to my special appearance. Appointment was later changed to that of standby counsel, DCD 20, and immediately withdrew his own, citing a conflict of interest. On December the 20th, 2017, an identity hearing was held, and it was determined that the defendant was indeed Michael Wayne Parsons, DCD 22. The court took up the matter of the government's motion to compel and received evidence. Michael Parsons wrote, again, hearing without advance notice to me, and argument from both the government and the defendant. In support of his argument that he was an ambassador, Parsons introduced several pieces. Mike wrote, this contradicts his statement on page 2, paragraph 2. The court found no evidence I am an ambassador. In support of his argument that he was an ambassador, Parsons introduced several pieces of documentary evidence. He introduced a letter addressed to the United Nations signed by Hereditary Grand Chief Stanley Stump Sr. announcing the new country of Chilcotin carved out in the province of British Columbia, Canada. And then Mike wrote, false, the Chilcotin Nation has been there long before British Columbia, Canada was made up. June 20th, 2016, EX 103. Parsons also introduced a document entitled Chilcotin Nation Letter of Appointment to Tribal Membership, which purported to make him an Associate Justice of the Universal Supreme Court of the Chilcotin and to confer full diplomatic immunity upon him, EX 107. He also introduced a letter from the Hereditary Grand Chief Stump dated April the 24th, 2017, which stated Parsons holds the position of ambassador, EX 112. In support of his claim to be an ambassador, he also introduced an identification card, EX 111, which represented he was an ambassador. With two exceptions, all the documents introduced by Parsons originated either with him, his associates, or representatives of the so-called Chilcotin. False, I did not create any of them. My signature is not on anything. Chilcotin National Congress. One of the exceptions was a birth certificate, example EX Exhibit 110, which showed he was born in Tennessee. Second, he introduced a single document, Exhibit 113, which bore the letterhead of the United States Department of State. The document does not indicate the United States Department of State recognizes Parsons as an ambassador. Rather, it was on its face a simple confirmation that Parsons had submitted an online application for a non-immigrant visa. The document indicated that Parsons had identified himself as an ambassador or public minister of the country of Chilcotin. Nothing in Exhibit 113 or any other document showed his application had been acted upon, or, more importantly, that the Department of State recognized Parsons as an ambassador. Not surprisingly, the magistrate judge refused to dismiss the charges. The magistrate judge also refused to recuse herself from further involvement in Parsons' case, DCD 34. Parsons objected to the magistrate judge's ruling, DCD 36, on December 29, 2017. The district court overruled Parsons' objections, DCD 37. In overruling the defendant's objections, the district court addressed Parsons' claim that he was an ambassador entitled to diplomatic immunity. The defendant also questions the court's jurisdiction over him, purporting to be a foreign ambassador and asserting diplomatic immunity pursuant to the Vienna Convention of Diplomatic Relations, Article 31, December the 13th, 1972, 23 UST 3227, but diplomatic status cannot be unilaterally established. Rather, it depends on recognition by the Department of State. See United States versus Lumumba, 741 F.2D, 1215, second D, 2D, Circuit 1984, AFFD, 794F. I'm not going to read all that. The defendant has given the court no evidence or any reason to believe that his supposed diplomatic status has been recognized by the State Department. Mike wrote, false. I cited VCDR 18, April the 1961, enacted into something 24th of April 1964. Treaty Series V9 500, page 95, Article 29, 31, 37, which states the immunity is effective from the moment the notification is made to the Ministry for Foreign Affairs, also known as State Department. On January 3rd, 2018, the defendant filed the instant interlocutory appeal of the district court's ruling. The United States court is moving this court to dismiss the defendant's appeal. Section 2, Standard of Review. An appellee may file a motion to dismiss a docketed appeal on the ground the appeal is not within the court's jurisdiction. However, such a motion to dismiss must be filed within 14 days after the court has docketed the appeal. Rule 47A, United States Court of Appeals for the 8th Circuit Local Rules. A district court's determination of disputed factual issues is reviewed for clear error. Compart's Boer Story versus United States, bunch of numbers. Section 3, Argument. The court has jurisdiction of appeals from all final decisions of the district courts of the United States. 28 U.S.C. 1291 interlocutory appeals, especially in criminal cases, are disfavored. Abney versus United States, 431 U.S. 651 656, 1977. Such appeals are available only in limited circumstances as set forth by the statute 28 U.S.C. 1292 or recognized by case law. The United States Supreme Court has recognized a limited case of district courts orders that may be taken up on interlocutory appeal by a defendant. Specifically, the Supreme Court has established the collateral order doctrine in criminal cases. Flanagan versus United States, 465 U.S. 259, 1984. Defense interlocutory appeals have been limited to denials of bail, motions to dismiss based on double jeopardy, and motions to assert immunity under the speech or debate clause of the Constitution. See United States versus Hollywood Motor Car Company, 458 U.S. 263, 265, 66, 1982. Parsons, of course, does not raise any such claims. His claim to entitlement to dismiss is predicated upon his supposed status as an ambassador of the recently created country of Chilcotin. Even assuming such a claim could be raised by interlocutory appeal, such an appeal is not appropriate on these facts. Richardson versus United States, 468 U.S. 317, 1984 instructs the appealability of a claim depends upon its being at least colorable. Richardson involved a double jeopardy claim. A colorable claim presupposes that there is some possible validity to a claim, ID at 326 N6. A claim is not colorable if no set of facts will support the assertion of the petitioner's claim of double jeopardy. Similarly, in United States versus Shelby, 604 F.3D 881 885, 5th Circuit 210, the 5th Circuit Court of Appeals held that a colorable, non-frivolous claim is a prerequisite to jurisdiction under 28 U.S.C. 1291 to hear a pretrial double jeopardy appeal. In the U.S. versus Abood, 273 F.3D 763 769, 8th Circuit 2001, the court observed the Aboods have not raised colorable claims of double jeopardy. For this reason, we lack jurisdiction over these interlocutory appeals, and they are dismissed. While these cases cited in the previous paragraph all dealt with double jeopardy claims, the point is still compelling. An interlocutory appeal should not be allowed to derail a criminal prosecution for months unless the claim is at least plausible on its face. In this case, Mr. Parsons' arguments are simply frivolous. He claims to be an ambassador of a newly created country carved out of Western Canada. He offered no evidence in support of this claim other than the documents authored by him or his compatriots. Mike wrote, the purpose of an interlocutory appeal is to prevent a miscarriage of justice, as is the case here. Diplomatic immunity and freedom of religion are not frivolous, let alone I am not the defendant. False. The country of Chilcotin is the Chilcotin nation, not Canada. The only purported official document was, and then Mike wrote, nothing was authored by me, and he offers no evidence to the contrary. Mine is the only evidence in the record. The only purported official document was Exhibit 113, which was a printout from the Department of State website showing he has submitted an online application for a non-immigrant visa. There was no showing made that the application was even granted. And then Mike wrote false. The word confirmation means authorized. The court has the authority, pursuant to Rule 47A, to dismiss this appeal on the grounds that the court does not have jurisdiction or because the appeal is frivolous and entirely without merit. Rule 47A, United States Court of Appeals for the 8th Circuit Local Rules. The United States respectfully submits that Parsons made no showing that he is entitled to the protection of diplomatic immunity. Representatives of the country of Chilcotin are not allowed to unilaterally declare themselves immune based upon frivolous claims of sovereignty. United States versus Lumumba, 578 F. Sub 100-103 SD, New York, 1983. Defendant claimed that he was Vice President and Minister of Justice of the Republic of New Africa, whose territory was claimed to span much of the American South. Claims of diplomatic status must be supported by showing that the United States, specifically the Department of State, has recognized such status. Mike wrote false. I have not only proven I am entitled to something Valitor, I can't read it, Halitor of Heredity, Grand Chief Stanley Stump Sr., but also proof of notification to the State Department and other authorization to, for, and a visa, A1 visa. Clearly, the racist and prejudicial attitude of the AUSA reeks of ignorance and Montevideo Convention on Rights and Duties of States and the Declaration of Independence and the definition of the word sovereignty, not to mention Canada recognition of the Tilshikotan Nation in the 2014 Tilshikotan Nation, British Columbia of SCC 44. The status of others as diplomatic agents hinges on the receiving state accepting the head of the mission. In the United States, recognition by the Department of State is necessary to establish diplomatic status. See also United States versus Al-Hamdi, 356 F.3D 564 573, 4th Circuit, 2004. The State Department certification is conclusive evidence of the diplomatic status of a person. Conclusion. Parsons has not offered any competent evidence to establish he is an ambassador of the country of Chilcotin or any other country. His appeal simply raises sovereign citizen arguments dressed up in other clothing. There is no basis under statute or case law allowing an interlocutory appeal on these facts. For all the reasons above, the United States respectfully submits that this court should dismiss the defendant's appeal. Mike wrote, now he claims the evidence is not competent. First, there was no evidence. Now it is not competent. Now he uses the FBI's demonization tactics against the sovereign Tilshikotan Nation, knowing he will never testify or submit under oath. He will twist, spin, and lie to fool anyone ignorant of the word sovereign, the VCDR, MCDR, Declaration of Independence, U.S., and Tilshikotan constitutions. United States of America, Plaintiff Robert C. Stewart, Acting United States Attorney, by Jan W. Sharp, Assistant United States Attorney in Omaha, Nebraska. Certificate of Service. I hereby certify that January 16, 2018, I electronically filed the foregoing with the Clerk of Court for the United States Court of Appeals for the 8th Circuit by using the CMECF system, which sent notification of said filing to the following: John Vanderslice, Assistant Federal Public Defender, and notification by U.S. mail to Michael Parsons in Saline County Law Enforcement Center. All right, well, that's the United States response to Michael Parsons' appeal with some notes from Michael Parsons. That document is on Year of Jubilee. It's right here at the very bottom of the page, U.S. response to Mike's appeal, if you want to download it and read it yourself. I do pray that you keep Mike Parsons, Pat Parsons, and Sue Holland in your prayers, and I pray that you take the time to write Mike Parsons a letter. Thank you for your time.